advertising on the Auto Trader website, that should subject them to jurisdiction in Texas, or as Mr. Weinkopf's brief states, really in any jurisdiction in the United States. As the discovery bears out, and Mr. Weinkopf saw, there was 2 cars that were sold into Texas in the last 3 years by my client, the company. Now the individuals are a separate issue. And the way that you probably are familiar with Auto Trader, it's really just an advertising website on which the cars are advertised, and then whoever wants to purchase it would go directly to the seller. So it's not a situation where you can buy a car on the website. It's not like the Keenan case, for example, that plaintiffs cite, where that case involved eBay, where that is very much a direct sell situation. So, our contention is that this is a very different situation, that our clients should not be.
How is Auto Trader really different than eBay?
You cannot make a sale of anything on Auto Trader. So it's really more just like advertising. Whereas on eBay, you go on the site and you actually purchase an item.
So, okay, so I know that there's certain websites where you can purchase a car on it. Auto Trader is not one of those.
That's my understanding, Judge. Yes.
Okay.
And so our client has literally, when I say our client, I'm speaking of the defendant, the actual entity that sold the car, which I think we've mentioned previously is misnamed in the pleading. There's some other party issues, but I'm referring to South Point Auto Plaza, Inc. So essentially, Your Honor, as I mentioned, 2 cars in 3 years. And, as we cite in our response, there are courts who have found that Auto Trader is not an interactive website, and that there's by using the Auto Trader website, that you're not targeting jurisdiction, or you're not targeting any specific jurisdiction. You're merely posting listings.
Okay.
So, Your Honor, our argument is essentially that there's just not enough minimum contacts to subject my New York client to jurisdiction here in Texas.
Response?
Yes, Your Honor. First of all, I believe by law, the affidavits attached to their amended special appearance need to be struck because they were filed within the 7-day period after the 7-day deadline in Rule 120A. Secondly, we're not claiming that this is a fully interactive website. We are claiming this is an interactive website, which it very much is. And that allows both the seller and the buyer to correspond with each other, allows them to be ranked in many things. It allows all sorts of things. And although 2 cars have been sold in Texas, what we're looking at here is it's a minimum contacts. They've availed themselves of the Texas market over 700 times in the last 3 years. And it's over that because they've sold 700 cars in that 36-month period. Who knows how many cars they've actually advertised to people in the Texas market, Texas residents.
I'm confused. Did they sell 700 cars in Texas?
No. They advertised. And so in sites like Auto Trader, you are allowed to use geofencing. In other words, you can restrict where that car is seen. And you can not restrict, which they have admitted they did not do any restrictions. So they knew these cars were being advertised in the Texas market. They knew they were availing themselves of the Texas market. 700 cars were sold. That means at least 700 cars were available for purchase in the state of by Texas residents from this outfit. And in addition, they currently have 83 cars listed on their website. But that's not the only thing. As in the Keegan case, you have to go a little bit deeper when you have an interactive, not fully interactive, but interactive website. And those are the other contacts that the defendants seem to be ignoring. First of all, there was the advertising. It was to a Texas resident. There is an exchange of texts. We have pled in the jurisdictional facts that there were phone calls, there were texts in which the condition of the vehicle was represented. was the representation of the condition of the vehicle on the actual Auto Trader listing, which we have not been provided a copy of. So we do have all of these, and so they have admitted they're fully responsible for the content of any of those
Are there
listings.
any cases that it kind of interpret how to look at auto? She said there was one that talked about how Auto Trader should be considered.
It's an Illinois federal court case, Your Honor, that they're referring to, and that's when you just look at Auto Trader as the only issue. The Texas case that we've cited, the Keenan case, goes into a much better analysis of, okay, you've got the interactive website, then you've got misrepresentations via text, misrepresentations via telephone, you've got money being transferred from a Texas bank, you've got the defendants arranging for shipping in this case, and they talk my guy out of coming up and driving the vehicle. No, we'll arrange shipping, because they knew full well if he would have seen that vehicle, he never would have bought it. And so you've got all of these other actions, and what the defendants want you to believe is, as long as you're advertising on an interactive website, it doesn't matter what you say to a Texas resident. It doesn't matter how you defraud them. It doesn't matter how you misrepresent things. You're never put into the jurisdiction of a Texas court, and that's just not right. They can't sit in New York and make all these misrepresentations and list things on the Auto Trader listing, list things in text messages that have been produced and are before the court, and phone calls that are part of our jurisdictional facts that we've listed, and then requiring payment. That's the Keenan case, same thing. They require payment from Texas, which we had 2 payments made from Texas here, in addition to arranging for the actual shipping of the vehicle to Texas. So there's a whole lot more than just the interaction with the plaintiff and the defendant on an interactive website called Auto Trader. And they've admitted they list on 4 other auto websites as well. So if this were a case of, hey, they listed it and there weren't all these other extenuating circumstances, which really go directly to, as the Keenan case talks about, these go directly to, and they're significant to, the causes of action that arise from these various contacts. So all these the texts, the phone calls, the misrepresentations, the arranging the shipping, everything else goes directly to the claims that the plaintiff is bringing in this case. And therefore, the court in Keenan, the Texas court, reaches the decision that the special appearance should be denied, and we believe the court should reach that same conclusion.
How do you distinguish the Keenan case, Ms. Ronell?
As I mentioned earlier, Your Honor, the Keenan case didn't involve Auto Trader. It involved eBay. It involved direct sales. And there was no dispute in that case as to whether it was an interactive website. And in Keenan, the court said, even assuming it was an interactive website, because there the parties didn't dispute it, you look to the degree of the interaction. Mr. Weinkauf is making all kinds of allegations about the merits of the case. And that doesn't have anything to do with whether our client should be held into a Texas court. There are numerous other cases that we've cited in our briefing, Your Honor, that, well, specifically the Auto Trader case, the court found that the mere use of autotrader.com website to advertise its vehicles does not establish targeting a specific market, in that case, Illinois, as required to establish specific jurisdiction. And we've not just cited the Illinois case. There's other Texas appeals court cases that we've cited, including the Riverside case, that even talking about the underlying activities, communicating with.
What other cases are there that discuss hailing someone into Texas based on a transaction that was facilitated by a interactive website but was closed in a different way? I mean, that's kind of what we have here, right? What case do you have that's most on point to that?
So, Your Honor, there's the one that let me see the name of this case. Here it is, the Riverside case. This talks about.
Can you share screen that case?
Sure. Yes. Can you see my screen now?
Yeah.
Okay, so this case, Your Honor, involved a Texas buyer of something from New Jersey. And again, they allege similar things that the plaintiff has here. And in that case, Your Honor, the court held that the defendant did not purposefully avail itself of the privilege of conducting activities in Texas by communicating with plaintiff by email. And, you know, here, all they've alleged is phone call, handful of text messages. And it says, you know, the physical address where one may send or retrieve an email is no more fixed for a particular location than the address where
Can you go down a little bit
Sorry.
on this one?
where one may send or receive a phone call. So let me get down to.
Keep going down. Term analysis. Go, keep going. This isn't a refund of a deposit case, right?
No, it's not, Your Honor. It just deals with it's not the specific actions that were taken as far as what was the quality of them. There's also emails that are referenced in this.
Go up a little bit. Citing two cases, let me see.
Mr. Weinkauf mentioned wiring money. Sending funds is not determinative.
Well, this says,
So if you look at each of the allegations he made, there's email contact, phone contact, and then the wiring money. All of those bases that he listed as sufficient are not, they're found not to be sufficient here in this case.
okay.
And this is the part here where it says that they don't avail themselves of conducting business in the state where you list something on a website for sale. In that case, it was a crane. Let me know if you'd like me to keep scrolling through. And there's other case law, Your Honor. There's a case out of the Fifth Circuit that says contracting with the resident of the forum state does not establish enough minimum contacts for specific jurisdiction. Neither does negotiating, communicating about, developing, or carrying out a contract. It does not purposefully avail you of the benefits and protections of Texas law. That's the Moncrief oil case citing another Holt oil case.
Okay, all right. Let me see this other case that Mr. Weinkauf was talking about.
The Keenan case, I don't know. I mean, do you have that handy? The Keenan case, and it's my understanding, is the only one that they're relying on it, and it's wholly differentiated given the nature of the fact that interactive wasn't even an issue.
All right, let me take a look.
Yeah, it actually was. And I think the case goes to distinguish that there are three types of websites that they look at in this. The first is a fully interactive, which is an actual auction
Can you share
website.
screen that case,
Sure.
please?
Let's see here. I'm showing my dinosaur tendencies, Your Honor.
I don't believe mine is shared any longer. Can you see anything?
Right. No, I took it down.
Oh, okay. Thank
Yeah.
you. I couldn't tell 100%.
No worries.
Can you see that, Your Honor?
Yeah. Take a look at it.
So they go into they talk about on the second page here. Tell me if I'm
Keep going.
I agree that their general jurisdiction does not apply, but they talk about in here about the various types. There's passive in the second column there, that first full paragraph. They talk about that there's a sliding scale of websites clearly used for transacting business over the internet. There's just the passive website, which is what the defendants are trying to paint AutoTrader as, but it's not. The very fact that it is interactive, that you can communicate back and forth between the seller and the buyer, that is the definition of
Keep
interactive.
going down a little bit, please.
Sure.
And they do specifically state in the Keeney case, Judge, that that the parties agreed it was an interactive website. So that was not an issue in this case.
So is it defendant's position that this was a static website?
Well, it's based on what we've seen in other cases relating to AutoTrader. They, as we mentioned previously, that doesn't constitute direct marketing into every state in the United States. And as to each of the kinds of underlying contact that you mentioned, that we cited Texas case law that shows that that is not subject to the party to specific jurisdiction in Texas.
So this one says, I mean, I agree that just if they had just advertised and no misrepresentations were made, but this talks about misrepresentations were made here in Texas.
And Judge, there's most certainly no admission of anything constituting a misrepresentation here.
Well, there's the known denial of it either, Your Honor. There's no affidavit saying we did not say those things.
Well, we haven't filed a general denial yet because of our special appearance.
Well, this was the time to bring it if you're trying to fight a special appearance, is to say that those do not go to, we did not do those things, and therefore.
Mr. Weinkauf, you're alleging that they made fraudulent misrepresentations, correct?
Well, we've attached the discovery responses, which include text messages. And my understanding of Rule 120A is that the jurisdictional facts that we plead are considered proven, and it is the defendant's job in a special appearance to refute those.
Okay, can you go down a little bit?
Yes, sir.
I mean, this kind of seems almost right on point.
Yes, sir.
Except, Judge, that interactivity was not on point there. And in eBay, you do buy directly from the website. That's completely different. You know,
I just want to make clear, if this was just a situation where they advertised on AutoTrader, I don't think that alone subjects them, but it's the additional activities of allegedly making a fraudulent statement and convincing them not to go to, I forget, it's in New Jersey. What state is this again? New Jersey?
it's
New
in
York, Your Honor.
New York, sorry.
And as to each of the other points that Mr. Weinkauf mentioned, I've cited case law here in Texas showing that emailing with plaintiffs, phone calls with a plaintiff in Texas is not sufficient.
Do you have any that says that making a fraudulent statement in order to close a deal is not sufficient?
No, Your Honor, there's no evidence in the record showing that anything was fraudulent. What Mr. Weinkauf is referring to doesn't show anything approaching misrepresentation or fraud. So, you know, that's not in any way.
Mr. Weinkauf, what exactly was done that you say was fraudulent?
Well, they sold it. They were aware that this vehicle was going to be used in my client's towing business. First of all, he couldn't even have it pass inspection and couldn't get it insured. It was in such bad condition that his insurance company refused to issue a policy of insurance on it. And it was in such bad condition, it could not possibly be used in the towing business, all of which were misrepresentations by the defendants.
And none of those are anything part of a factual record in this case, Your Honor.
They've been pled.
Were they pled?
Yes, Your Honor.
They may be in his initial, just his attorney, you know, in his actual pleading, but just pleading something doesn't subject someone to jurisdiction in the court, Your Honor. I mean, basically, any defendant who advertises on Auto Trader, if we're held into court in Texas, any defendant who advertises on Auto Trader, any company, would be subject to jurisdiction in every single state, regardless of how minimal the contacts will be. And, you have to look at the degree of the underlying activity if you go to that level. And, it doesn't necessarily, again, there's no proof of any misrepresentations or fraud here, Judge. And, our client, the kind of minimum contacts that are at issue here, it's not even remotely close call. I mean, it's, they try to make it out as if it's 700 cars. There's 2 cars in 3 years. And the plaintiff initiated the contact, and, they paid for the shipping. Where they paid from, again, I've cited a case here today under Texas law that does not warrant minimum contacts in this jurisdiction.
So Texas case law is that a hearing on a special appearance, the non-resident defendant must disprove jurisdiction by negating all alleged grounds for personal jurisdiction. If the defendant does not provide sufficient evidence in support of its special appearance, the court should deny the motion. I mean, so it is kind of your burden to show, right, that by evidence that these statements were not fraudulent.
I would just disagree, Your Honor. Actually, we have to show us to the jurisdictional allegations, not to the underlying merits of the case. So we basically don't have to prove their entire case false. We just have to show that their jurisdictional allegations are not correct. And
Were your statements about fraud part of your jurisdictional allegations, Mr. Wenkoff?
Yes, it says that these were misrepresentations. The texts were misrepresentations.
And Your Honor, the degree of the interaction is what we're talking about here. If you're looking at this analysis, not the substance of the merits of the case. And, our clients very much deny that they have done anything wrong in this case. And, that it would set a very dangerous precedent for 2 cars sold into a state based on an advertisement on Auto Trader to subject a company to jurisdiction in every single state.
Your Honor,
I don't think that's what's happening here. I understand I don't think that's what's happening, but I'm not trying to look at the jurisdictional. So I'm looking at your original petition right now.
We have filed a first amended petition, Your Honor, based on the additional information we received in the defendant's written discovery responses.
All right, let me see those. When was that filed?
It would have been at the end of November.
I see it. Okay. So let me share screen this, so we're still all on the same page. Go ahead and stop sharing this. Okay, do you guys see that?
No, sir. Oh, it's coming up, Your Honor.
All right, so part of his jurisdictional facts, these are not the merits, Ms. Rynell. It talks about in paragraph 10, I guess, that began exchanging texts. They made it misrepresentations or representations. And then he relied on those. I mean, I think he's pled all of this stuff within his I mean, this is much more extensive than I usually see on jurisdictional facts, but and that the statements were false, they were made intentionally. I mean, you can't, I mean, I think what the case that he's cited says is that if you reach out to a Texas resident and make misrepresentations to them, you can be held into Texas. I think Texas has an interest to keep that from happening. Um,
I understand that that's what he's arguing, Your Honor. I think that it's very different in this case because if you look at the sliding scale that he mentioned, the eBay website is very far on the
I don't know that that makes any difference to my analysis. It's not the type of the website. It's I think even if he had been in a situation where I'm trying to think of just if it was a completely non-interactive website and they posted that and then later made those misrepresentations, I think it would still be sufficient to confer jurisdiction, um, given they reached out to Texas and then um, made these misrepresentations. All right, I'm going to deny the special appearance. Anything else today, guys?
No, Your Honor. I'll submit an order.
Have you done already?
I don't believe I have, because I didn't know about the other parties, so the
What
special
should be,
appearance.
are there other parties? I'm sorry.
yes, Your Honor, the
Let's talk briefly.
individuals. So they've sued um, the owners of the company individually and doing business as the company. So
Right. So let's break that down. So who is the individual who made the misrepresentation?
it's one of the owners of the company, Your Honor. So they have not, there's no
And
basis.
okay, so that owner, I'm going to find has subjected himself to jurisdiction. What about the other owner?
There's literally no allegations that they make specifically as to why an owner of a business based on alter ego, for example, should be hailed into a court for something that
Miss Rhino, I'm just trying to ask you a question. Okay, so
Sure.
I'm really am trying to help. I understand you don't agree. That's fine. Will be the first time I've had an attorney not agree with my ruling. I'm not trying to make this any more difficult. What I'm asking is that there's two individual defendants that were sued. Is that right?
Yes, that's correct. So it's Yusuf and Salim, and
And then one of them made a misrepresentation allegedly to the plaintiff, correct?
Yes.
And then the
I,
other
bel- I,
one,
I
and
believe
the,
it's only one, Your Honor.
Yusuf was actually, as we mentioned in our filing, Yusuf was non-suited. So he only actually was brought to the case again, just recently within the last week or so. And he
Okay.
wasn't, and they just added him back in. So we, out of abundance of caution, we filed the special appearance on behalf of Yusuf. But he was non-suited originally. And so he was just
So
brought back
this special appearance is only as to the corporate defendant?
in. The special appearance is to all defendants, Your Honor. But they don't have any minimum contacts as to the
So-
individuals.
Okay, so the special appearance I'm hearing today is involving which parties?
It's involving all the parties, involving Yusuf, Taliji, Salem, Taliji.
You can't, if one of the defendants was just added, or one of the defendants was just added, you can't do a special appearance on it, right? You'd have to go through the whole process again, correct?
May I speak to that briefly, Your Honor?
Yeah.
The reason that Yusuf Taliji was non-suited was because I'd filed a motion for default judgment because none of them had answered, and then we found out that he had filed, I don't know if it was a holographic answer or what it was, but we hadn't been served with it. So we non-suited him so the court could go ahead and have the default judgment prove up, and then subsequently the rest of them all answered. So we're going to be bringing him back in, but I understand this would only apply to Sam Taliji and the two corporate entities.
Okay, so let me, I'm really trying to hone in on this. So Sam Taliji is who?
He is one of the owners of the business.
And did you allege, Mr. Weinkauf, it's just to Mr. Weinkauf, that he made any fraudulent statements to your client?
Let me check real quick, Your Honor, because I did have that pulled up.
I did not, there's nothing as far as we can see, Your Honor. And there's certainly no allegations that in his individual capacity or Yusuf's that they did anything relating to Texas.
Uh,
I'm checking, Your Honor. I was just looking
it
at
says
the
there's a Joe
text.
Taligi, Yosef Taligi. It says that Joe Taligi, is this the same person?
That's Yusuf is Yusuf, the one that they monsooned.
Okay.
I believe the only one that had the text exchange was Yosef Joe.
Okay. So the other defendant, okay. There's Yusuf. This is confusing. Okay. And
Salem, is the other name.
is there, I don't see him in here. Is he?
He's in the very middle of the caption. He's not listed as having done anything in particular in their pleadings.
Okay. I'm granting the special appearance as the Salem Taligi. Okay. And then who did Yosef Taligi, who did they actually buy the car from? Why are there two different parties?
They actually bought it, Judge, from the company is called South Point Auto Plaza Inc. And we've repeatedly told Mr. Weinkopf that that's the entity. We've included it in our special appearance. So I'm not sure what the other.
I can explain that, Your Honor. The reason is that South Point Auto Center is the one that arranged for the shipping of the vehicle.
Right. I'm going to grant a special appearance as to them, deny it as to South Point Auto Plaza, I guess, Inc., if that's what it's called. And then, I mean, obviously, Miss Right now, you can do whatever you want, but just if you, to the extent that my reasoning resonates at all with you, then the Yosef Taligi would be, I would anticipate I would deny the special appearance as to him because he's the one who actually made the alleged misrepresentations, if that makes sense. So, Mr. Weinkopf, do you understand my ruling?
Yes, Your Honor, I do.
Ms. Reinell, do you understand the ruling?
I believe so, Judge. So you're not, you're reserving judgment as to Yusuf currently.
Because I just don't think it's right. If he just
agree.
added him back in, I don't think it would be right, but you'd have to go through the whole process again. So go ahead and get me an order on that, Mr. Weinkopf. Indicate that this was filed on, or this was heard on December 16, 2024 over Zoom. Make sure you share that with Ms. Reinell and get me a copy of the order by tomorrow, okay?
Yes, Your Honor, I will.
All right. Thank you, guys. You have a great rest of your day, okay?
Thank you for your time, Your Honor.
Thank
Good
you.
day.
Bye. All right, our next hearing is anyone here on Smith versus Post Oak Title?
Your Honor, present for the defendant, Galen Rogers.
Tom McMurray for the plaintiff, Edward Smith, Your Honor.
All right. Let's go on the record on DC 225474. Edward Smith versus Post Oak Title Company. Counsel, make your appearance.
So Thomas McMurray as the plaintiff's lawyer for Edward Smith.
Your Honor, Robert Newark on behalf of defendant Galen Lonergan Rogers.
All right, so I've reviewed the briefing here, and I have one major concern here is which at least what I've seen, and sometimes it gets lost in our system, but I want to make sure that there was a response filed by the defendant in this case back on December 12th. So is that the only response you filed, Mr. Newark?
Your Honor, as it relates to this summary judgment, that's correct.
All right. So there's obviously two big problems with the response. One, it was untimely, and two, it didn't have any evidence attached to it, correct?
That's correct, Your Honor.
Okay. All right, Mr. McMurray, you can begin.
And Your Honor, I don't know if the court saw it was accepted Friday that we did file a reply. We
I did, and
misnomered
I read it.
Okay, we misnomered it as a response to the to the defendant's response. Sorry about that, but we
That's
did.
okay. No worries.
Your Honor, in this case, we're set for trial in the early next year, and this is a partial summary judgment on two fronts. One's a traditional on the issue of liability only as to the plaintiff's claims for negligence and the plaintiff's claims for breach of fiduciary duty as to Miss Lonergan. The defense calls her Lonergan Rogers, so we'll say Lonergan Rogers. We knew her as Miss Lonergan, and she is an attorney, and she is licensed in the state of Texas. We have an expert, Richard Hayes, who is a legislator fixing us go to a session, and he is an expert in real estate, title, and escrow officers, and he is uncontroverted. Further, the Ms. Lonergan Rogers has failed to even file any answers to disclosures, and they did not file any designation of any experts at all. This is timely due to the fact that we are coming up on the trial in another month and a half. And at this point, we are trying to clean up the trial to narrow the issues. The court should grant the traditional motion for summary judgment in that Ms. Lonergan in Exhibit C and in Exhibit K, these are the two residential contracts. She took on the duty as the escrow officer, and the instructions were to put the deposit of the escrow money with her, and then the closing should take place at a location called Post Oak Title with attorney Lonergan. Ms. Lonergan did appear. Ms. Lonergan did execute the special warranty deed that my client executed, which is Smith, to this BAPA Brooklyn group, and she was the notary on the instrument. Further, she told my client that she had the $250,000 in her IOLTA account, of which has never been tendered, nor do we even believe it occurred. Not sure why she took that tact, but she did. And further, in Texas, an attorney can be a escrow officer. We are accepted from the particular licensing requirements because of our law licenses, and also case law and Supreme Court has ruled that we are authorized to do such actions. Once we do take on those actions, then we owe a fiduciary duty to both parties to be basically neutral, but make sure that the closing is done per instructions. Ms. Lonergan fell below the standard of care, and both as a negligence by allowing the deed to be filed of record that granted BAPA Brooklyn their grant, which allowed them to get the property away from my client because he granted them the property, but she failed to ensure that it was paid for through the double close. This was a double closing that was to occur simultaneously. At the end of the day, my client was damaged. We would anticipate a short trial on damages. We did not set the summary judgment up for it, but the evidence shows that there are damages from the actions by Ms. Lonergan. On the no evidence summary judgment, Ms. Lonergan filed a counter petition wherein she alleged defamation against Mr. Smith, and we filed a no evidence summary judgment, of which there's been no response, no evidence tendered that would even give us any scintilla of anything. Under 166 AI, the court is instructed to grant summary judgments on no evidence when the non-movement, once the burden has been transferred to the non-movement, which the plaintiff here is the movement, defendant would be the non-movement. once that motion is spelled out in the elements with specificity, which it was, then the non-moving has a duty to advise the court of at least a scintilla of evidence that would show it could support its claims, where it has the affirmative burden to carry those claims. Since it's a counterclaim for defamation, it would be her burden to prove at trial. And so the court should grant the no evidence summary judgment on defamation. In addition, if you file affirmative defenses, which you're allowed to do, and you have a burden to prove, more likely than not, the affirmative defense to a claim, then again, you have the burden to prove either to the court or jury those issues. We filed a no evidence summary judgment on the affirmative defenses. And here, although I don't legally believe that they all apply to our case, it matters not because we're cleaning up these pleadings, but they claimed an assumption of risk doctrine. There's no evidence been brought forth to defeat the no evidence summary judgment. They filed a statute of frauds, which under 2601, however, none of the 8 elements that a statute of frauds applies would apply to a breach of fiduciary duty or negligence by an escrow officer. That's not even applicable. So the court should grant the no evidence statute of frauds motion. Then you also have, they basically allege fraud as an affirmative defense, but even if you brought it either way as a counterclaim, or if they brought it as affirmative defense, they've brought no evidence. We have laid out that there's been no misrepresentations by Mr. Smith, and basically they're trying to shift the burden to the guy that got screwed in this deal. Not sure what their thought on that is, but that's what they did. So the court should grant the no evidence summary judgment on fraud as an affirmative defense. Let's see. I thought there was one.
All right, let me hear the response.
There was some kind of unclean hands, which is an equitable claim, but I don't think it applies, but we would ask for it anyway. Sorry, I'll pass, Your Honor.
Okay. Response?
Your Honor, if I could address the first portion of the motion, not the no evidence portion, but the first portion, the traditional. Our response says that there was no agreement between the parties to establish this escrow officer. That's the whole crux of the plaintiff's case, is that my client was an escrow officer. And I cited some cases. Those cases clearly say that you have to have an escrow agreement. It spells out the terms necessary for the escrow officer. And when an attorney can be an escrow officer, we would concede that point, but there needs to be an escrow agreement. Without the escrow agreement, there's no breach of anything. So that makes that particular provision fatal. There's no way to move forward. As it relates to the breach of fiduciary duty, there's no establishment that there was the fiduciary duty because there's no escrow agreement, and they have never produced a copy of the escrow agreement because it doesn't exist. So, Your Honor, as it relates to traditional motion for summary judgment, we think the court must deny that motion as it relates to that provision, because there's no evidence to support all the elements necessary to prove their case. Let me correct that. I misspoke. At least the initial element that there was an escrow establishment, and so you have a breach and you have a duty of care and all those things. Your Honor, the court, when we started this hearing, asked about the no evidence portion, and we provided the evidence. The court has pointed that out to us. We did not provide any. We would agree that we didn't provide any evidence, and we would stand on the court's analysis. Even though there's not any evidence produced, the court still has a duty to review the evidence provided in the case. And if the court deems that that portion should be granted, we would say that that's what the law is. As a housekeeping measure, I'm not quite sure the plaintiff's position about disclosures. We made initial disclosures in the case. We did not disclose the expert yet, but we do not have a duty to produce any others, I think, for 30 days. So we're working on that and would get that done. But as it relates to initial disclosures, that's been provided, Your Honor. So I don't know what disclosure she's talking about. I don't know if that's even relevant to the court's analysis. I just want to make sure that's been disclosed, Your Honor.
So I'm going to grant the summary judgment, the no evidence summary judgment. Let me hear your response, Mr. Corey, about the traditional and the argument about not having an escrow agreement.
Yes, Your Honor. Thank you. Mr. Newark is completely wrong. The Texas courts do imply an escrow agency relationship by conduct absent any formal escrow agreement where the third party, here Lonergan, accepts documents, accepts and funds disbursements, and transfers property at closing. She took the deed, the special warranty deed by Smith, granted to BAPA, and it was filed of record under her watch. She was the one that had control of the document, and she's the one that notarized the document. Our expert, Richard Hayes, he spells that out in his testimony that's uncontroverted by Ms. Lonergan in his affidavit on page 3 of his affidavit, which is competent summary judgment evidence. Further, the trial is whatever that term means as far as the summary judgment is today. So they can't come back later and say, well, we've got more evidence we would give you, Judge. They've only had about 1.5 years to do something. So, or 2, this thing's old. And so I don't know what they're waiting on, but forget that. There is no requirement that you have a written escrow agreement, especially with an attorney. There's even exceptions to attorneys because that's why they're not licensed as the escrow officers like a title company would have to have for a non-lawyer. So, in all fairness to Honorable Newark here, he's wrong on that. The court.
Let me go to. I want to see page 3 of this affidavit you're talking about.
Sure.
So go to that.
It's in my. It's a. Let me see what exhibit we called it. We called it G as in George. G.
Yeah. Do you happen to know which page it is?
Maybe. Give me a second.
No, I found it. I found it.
Sorry. You did? Sorry about that.
That's okay.
It's the 4th full paragraph.
Sorry, I'm trying to get to that page. Okay.
Oh, sorry about that.
No, I was pressing the mouse and it was just going through too fast to me. Okay, so let me share screen and make sure I'm on the correct exhibit. Is that the exhibit you're talking about?
Yes, Your Honor, it is. If you went to, that's page 1 of that exhibit. If you go
said to page 3?
Yes, sir. Page G3. Yes, sir.
This is it. Okay. And then where?
If you look at the 4th full paragraph, Mr. Hayes gives his opinion that Texas courts imply an escrow agency, and then it goes on to spell that out. And then above it, he says Lonergan had a fiduciary duty to not file of record any instrument.
Did you, I don't know that you had to, but did you plead that this was a implied escrow agreement or escrow relationship?
I think we just pled it as an attorney escrow relationship. So I don't know if we did that exact word like implied, but we did say it was an attorney escrow relationship.
All right. Mr. Newark, did you want to say anything else?
Your Honor, the only thing I would say is I don't recall them arguing an implied agreement. I would tell the court that even when they look at the exhibit, while this is just an exhibit, it's just an expert's opinion. There's not any case law that would show that. It just says Texas courts do that.
Yeah.
I think that there are some facts issues here, and that the court should deny the motion for summary judgment on that traditional portion of it, Your Honor.
All right, I'm gonna grant the summary judgment as let me just go through this paragraph by paragraph. Okay.
You
Yeah,
have our proposed order, Your Honor. We
I
sent
do
one.
that. That's what I'm sorry. Maybe you can't. I thought you could see it, but I'm probably not sharing it correctly. Let's see.
I'm not a good Zoom person, so I'm sorry.
That's all right. Do you see that?
Yes, Your Honor. I do.
Yes, Your Honor.
Yes, Your Honor.
All right.
I see it. Yes, sir.
I don't know that I like the term defendant is liable for the cause of action. I'm going to cross that one out. I'm going to. All right. I guess that's about as good as okay. Now that's fine. All right. Let's see. All right. And let me just say this to you guys. This case is really old. And so it is highly likely you'll get reached in January. Have you guys been to mediation on this or?
We are going this week. We were waiting on this ruling, actually.
Okay.
We're scheduled for the 27th, Your Honor.
So,
Well,
Your Honor, to make sure for our mediation, you are granting the summary judgment on liability?
on as to the cause of action of fiduciary duty, yes.
Okay.
I don't know if there's any others, but on fiduciary duty.
There was two, one for negligence and one for fiduciary duty. They're alternative causes of action, so it'll help our mediation to know that that's what was granted.
Yes. Oh, sorry. Here we go. It's just as the fiduciary duty. So
That's fine. I just wanted to make sure I understood so that when we go to mediation, I don't mislead the mediator.
who are you mediating with?
Ooh, who's it?
Rubenstein, I think. Rubenstein, Your Honor. I think that's right.
I think so, Your Honor.
I
Yeah.
mediated with him many times when I was in private practice. He's an excellent mediator. All right, guys. You guys have a great rest of your day. Good luck at your mediation and let us know if you settle, okay?
Okay,
Thank you, Your
thank
Honor.
you. Thank you, Your Honor.
Thank you guys. Happy holidays.
All right,
Thank you.
bye-bye.
All righty. Our next hearing is all right. Let's go on the record. Tony, are you ready?
Okay.
Ready.
Let's go on the record on DC 249773, Security National Bank of Omaha versus Robert DeFonso et al. Counsel and parties make your appearance.
Richard Ilmer on behalf of Security National Bank of Omaha, the plaintiff and movant today, Your Honor.
Your Honor, my name is Robert DeFonso. This is Grayson DeFonso. We are here pro se. We don't have counsel this time.
Okay. So do you understand the procedure that we are going through today?
We don't understand it at a full capacity because we don't have the ability to, or we did not have the ability to retain counsel to understand the severity of the judgment. We received notice on November 18th, I believe, of this appearance. And so we're here to understand and share our, I guess, testimony towards this. But no, we do not completely understand it.
So let me kind of give you a brief. I'm not your attorney. I'd highly recommend you get an attorney. But just kind of from a very basic standpoint, what's happening is that this is what's called a motion for summary judgment. They are trying to essentially end the case now by getting a judgment against you. Under Texas law, you're required to file a response to summary judgment at least 7 days before the hearing. And as a judge, I have to follow the law. The law does not permit me to let you testify during this hearing. And so you can argue during the hearing, but in order for you to provide any evidence, it had to be produced 7 days in advance of trial. Does that make sense?
Yes, we understand.
All right. Mr. Elmer, you may begin.
Thank you, Your Honor. If you've had a chance to review the motion prior to the hearing today, you'll see this is a pretty straightforward action for collection of a debt. It's a suit against the defendants as guarantors of two promissory notes. There were two promissory notes, one for $2,500,000, the other for $250,000. And as set forth in the papers, one of the notes completely matured. The larger of the note went into default, was accelerated, no payment was made. The smaller note matured as a matter of law. It remains unpaid. And so really this is just a motion for summary judgment on two outstanding debts. I don't think there certainly isn't any response on file to raise a genuine issue of material fact. I don't think there is any genuine issue of material fact. On the two notes, the evidence is supported by the affidavit of John Harala from the bank. We attached all of the commercial loan instruments, as you can see. We supported the amount due with his affidavit. Scrolling. Oh, I'm sorry. I thought I was sharing screen. May I share the screen, Your Honor?
You may.
Give me just 1 second. So the motion is supported by the affidavit of John Harala. After attaching all of the records, he goes through and tells exactly how much is due on each note, what the total amount due is, both principal and interest. I believe and this was as of September 11th. On the larger note, there was $2,736,595.38 due. And on note 2, it was $268,619.79. The larger note had a per diem interest rate or per diem interest of $603.64 per day. The smaller note was $67.71 per day. So when you add all that together, the total amount due as of today, that would be through December 16th, 2024, is $3,070,318.66. So again, that would be 3,070,318.66. And so that's the amount that we're asking for on this collection action. We did reserve the right to supplement our evidence on attorney's fees at the conclusion of the hearing. At the time we filed the motion, of course, I wasn't certain if we would have a response and a reply that we would have to go through. So I would ask the court for leave to just submit an affidavit on attorney's fees. I can tell you that I think as of today, or as of going into today, the amount was like $7,500. So by the time we get everything all said and done, it'll be $10,000 or less. And so we'd ask for leave to just submit an affidavit on attorney's fees to go with the proposed final judgment for the total amount due.
Did you submit any attorney's fees affidavit?
We did not. We reserve the right to come back to the court on that later.
Response?
The current situation for Grayson and I is we are in a Chapter 11 bankruptcy filing for DeFonso Holdings, LLC, which is the entity that Grayson and I founded in 2010. We received the Main Street loan through that entity along with the line of credit. We have been working towards a petition and a plan to under the Chapter 11 filing under Subchapter 5 to restructure that debt repayment. We are currently working through that plan, and that plan has been pushed into next year, into January. Our hopes were to manage that process as best as possible. We were not sure of what the summary judgment was until recently. So our response is really we don't have any evidence to refute the fact that we did sign the personal agreements. We do know that inside of the exhibit, there is only one area that we would like to call to attention, and that is the material adverse event, which is page 8 of the exhibit. That if we could provide a response, it could lend some understanding as to why we are here where we are today. Our business is built on wholesale, so we design and manufacture product for small businesses around the country. Late of 2023, we produced around $3 million worth of goods. And starting in the later part of 2023 and then all the way through this year, 2024, we were unable to collect on the majority of those goods, which reduced our revenue by more than 50%, deteriorating our business, which pushed us into a Chapter 11 filing, and now into.
Let me ask a quick question here. So, this is only against them individually, is that right, Mr. Elmer?
That's correct, Your Honor. They have a corporation. It is in bankruptcy. They personally guarantee the debts of the entity of the corporation. So this is separate and apart. This is against them as guarantors of the debt that was taken out by the company.
Okay. Anything else, Mr. DeFonso?
No.
All right. So, Mr. Elmer, I have to be fair to both sides here. So I'm going to grant the summary judgment. If you want to reserve to try to get attorney's fees, you'd need to file a new summary judgment, and this would be a partial motion. I'm not going to just let you supplement it, just like I'm not going to let them supplement it. So I can give you the judgment without attorney's fees. I can do it as a partial judgment without attorney's fees. It can be a final judgment without attorney's fees, a partial judgment without attorney's fees. It's kind of your choice.
Might I visit with my client and let the court and the defendants know at the same time, Your Honor?
If you can do it right now.
Okay. May I put you on, may I put this on mute and turn off the
Sure.
video and call my client and call you right back, and come right back here?
Sure, no problem.
Okay. Thank you, Your Honor. Just give me one moment. Your Honor? Oh,
Okay, what's up?
Your Honor, my client says they'll forego the attorney's fees and take the judgment on the 3,070,000 today.
Okay, let me take a look at the order. I'm going to share screen the order so that you guys can see kind of what it says, Mr. DeFonso. Well, you should have gotten a copy of it. And Mr. DeFonso.
Yeah, it's got blanks in it. You'll have to fill in, Your Honor.
All right, so what is the amount of the damages exactly? Wait, no. All right, I'm confused how you did this. Let's see. I see. Okay, amount of damages. All right, what's the total amount?
I'm going to just give you the number so you can type them in. 3,070, 318.66 through December 16th, 2024.
Through December 16, 2024. Okay.
Correct. And then you can delete the remainder about attorney's fees, strike through it.
Okay. Okay.
It'll be the same thing in the second paragraph.
Tell me the number again.
3,070, 318.66 through December 16th, 2024.
All right, Mr. DeFonso, do you have any questions, or Mrs. DeFonso?
I guess the question is we're not really sure what we'll do going forward. Is there documentation or something that we're able to read to understand what we need to do now that the judgment has been granted?
What, I'm not sure what you mean, like credit counseling, or what do you mean?
I guess when will this $3 million need to be paid, and you know how we're supposed to go about meeting the judgment.
Mr. Elmer, do you have any comments on that?
Yeah, I'm happy to comment. So the judgment won't be final for 30 days. During that period of time, you have the opportunity to go see a lawyer, see if you want to appeal. Obviously, I do suggest you go see a lawyer, talk to that lawyer about your options. You're welcome to have that lawyer call me, but generally the judgment won't become final for 30 days. So you have that period of time to get together with a lawyer and try and figure out what to do.
You know, it might not be a bad idea if you can to try to, you know, talk to Mr. Elmer about a way to structure out. A lot of people in this situation, if they can, will do some kind of payout. This is obviously quite a bit of money, but people do payouts and things like that. I don't know what your situation is, but you might want to consider that as well. But
Okay.
do you have any other questions, guys?
Well, I do. So in the case against my company,
Well, that's separate from this.
so I would owe for both. I don't understand that.
Yeah, you would not owe for both. If there's a payment, if you guys pay on this debt, it will offset what the company owes in that other proceeding.
Okay, so it's two different cases, but the money all goes towards one.
Debt.
Okay.
So let's say you made a $100,000 payment in this one, it would decrease your payment that you would need to pay in the other one.
Okay.
Did you have any other questions?
No more questions. I guess, Mr. Ilmer, I will reach out to you just to ask a couple of questions off in regards to payments and structuring something like that. We will use the next 30 days to try and retain counsel, just to make sure that we are doing our best and our most due diligence here.
Very good.
And just so it's clear, I've signed the order today. So if you're talking to an attorney that may ask you, because the 30 days runs from the date I signed it today, and it is a final judgment. So you do have 30 days. They'll probably ask you that. So a final judgment was signed today. So we wish you the very best of luck. I'm so sorry you're going through this, and I hope it all works out. And you guys have a great rest of your day.